Good afternoon, everyone. Thank you for joining us for today's HUD CARES Act conference session. Today we're going to be discussing the HOPWA property standards and rent reasonableness standards waivers for the HOPWA program. Just to start out with some housekeeping, today's PowerPoint and recording will be posted to the HUD Exchange for future reference. You are all in listen only mode, so you won't be able to unmute yourself to ask any questions. So please keep that in mind as we move forward. If you do need any closed captions, please follow the directions here, and you should have received an email about an attendee guide if you have any other information. Also, feel free to throw anything into the chat box if you do need any tech support. So for questions, if you do have questions today about any of our topics, please submit your content-related questions to the Q&A feature below your video player. We'll be able to review them and answer them as we go along. You can submit them throughout the presentation. You do not need to wait until the end. But please make sure to submit those questions via the Q&A function, not the chat. Speaking of the chat, once again, please use the chat for technical issues. Request assistance through the chat box on the right-hand side of the screen. If you have any other technical issues, you can email the event support staff. With that out of the way, since we're discussing HOPWA, also feel free to use the chat feature for any suggestions that your community has done to implement any of the HOPWA waivers. So if you have some good ideas on how you've done remote initial inspections, right, throw those into the chat so your fellow participants can think about how they also can implement some of these waivers as they still have the time to do so. So my name is Steve Ellis. I'm with the Cloudburst Group. I am presenting today with Heather Rhoda, also with the Cloudburst Group. In the background, we have two employees from HUD's Office of HIV Housing, or OHH, Rita Harcrow, the director, and Amy Palalonis, deputy director, who will be here to help answer any questions and to chime in during the Q&A. All right, let's look at our agenda for today. So we're going to break up today's session into three different sections. The HOPWA waivers, just a quick status update. We're going to go over then some updates and reminders and considerations for the waivers. And then particularly since the rent standard waiver is tied to rent reasonableness, we're going to give you a refresher on rent reasonableness to make sure you understand it, to make sure you're implementing it correctly, to make sure you're documenting it for your file. So let's jump right in to the next slide. So section 1, we're going to discuss the HOPWA waiver status. So in case you haven't heard, although at this point I'm sure you have, that on December 30th, 2021, HUD published another memo that helped extend some of the waivers that had been in place for a number of CPD programs. For the HOPWA program, it set an expiration date for the HOPWA and space security waiver. It extended the HOPWA property standards waiver that had previously expired on September 30th. And it extended the HOPWA fair market rent standard waiver that had expired on December 30th. The memorandum also included an announcement for how grantees could communicate with HUD and CPD that they plan on using these. So for the grantees listening, please make sure to flip to that last page of the waiver about how to communicate this to HUD if you've not yet done so. So, and we'll also make sure to include the hyperlink for this memo into the chat box. So that way, if you do need a link to find the memo, you'll be able to access it quickly.
And Steve, I already did that.
Thank you. So just real quick for any grantees out there who've not yet notified their HUD of their intent to use this, the notification process, please make sure that you've notified HUD of your intent to use these waivers at least 2 days before the grantee anticipates using them. That email should include the requester's name, their title and contact information, the date for which you first anticipate to use any of the waivers that are outlined, and a list of all of the waivers that you'll be using. Each community is a little different, so this is possible you've already done so, particularly maybe someone in your department emailed HUD for all of the waivers for all the CPD programs available. Maybe they haven't. So internally as grantees, if you're not sure, definitely reach out to others in your department who might have done this before for previous waivers, because you want to make sure to keep a copy of that notification in your documentation and record keeping. So when it comes time for HUD to monitor, you're sure to line all of that up. If you do have any questions about monitoring, particularly with the CARES Act, there was a session yesterday. I believe that recording's up on the conference agenda website. And once again, all of these sessions will end up on the HUD Exchange. So what about the other waivers, right? So the CPD memo for HOPWA talked about 3, but it did not talk about 2 others. So what it didn't talk about was the self-certification of income and credible info on HIV status and the time limits for short-term housing and STIRMU. So those waivers have expired and cannot be renewed. We won't be covering these today since they were part of previous waivers. So if you do have any questions about these 2 topics or waivers, please make sure to look at some of the previous HOPWA office hours that have covered these topics. You can use this hyperlink here. We'll also throw the hyperlink into the chat box if you'd like a direct link to that material. So for our second section, we're just going to break down those 3 waivers that were mentioned in the memo itself. So we just want to give you some updates, some reminders and considerations on space and security, property standards, and HOPWA rent standards. So when it comes to the space and security waiver, this space and security requirement had previously not had an end date and is now expires on March 31st, 2022. So this waiver allowed grantees appropriate quarantine space for affected eligible households for allotted quarantine time recommended by local healthcare professionals. So as I mentioned, previously this waiver did not have an end date and is now March 31st. So this allowed grantees and project sponsors operating housing facilities and shared housing arrangements that still needed flexibility to make sure there's appropriate spaces for quarantine for eligible households affected by COVID-19. So this meant that programs could now use other spaces or putting families in a hotel or motel room when needed to make sure there is adequate space and security for themselves and their belongings. Once again, if you have any question about this waiver, please feel free to reach out. Particularly project sponsors, reach out to your grantee, reach out to any of your TA resources. Because for the rest of today, we're going to focus on the 2 other memos. The first being the property standards waiver. So while this property standards waiver had previously expired, under the new memo, the waiver flexibility was reintroduced and now expires on March 31st, 2022 for grantees and project sponsors that meet the following criteria. A grantee or project sponsor must be able to visually inspect the unit using technology such as video streaming to ensure the unit meets HQS or habitability requirements before any assistance is provided. So once again, this means that this only applies to initial inspections, not annual inspections. We'll go over annuals in just a moment. But furthermore, the grantee or project sponsor also has to have written policies that require a physical reinspection of units that didn't have that initial physical inspection by June 30th, 2022. So while this waiver is an option for communities that need it, remember, it's perfectly okay to conduct in-person inspections, particularly initial inspections, if it's safe to do so. Many grantees and project sponsors have already been conducting safe, socially distanced in-person inspections. So this waiver is only in place for those that need to do so for their initial inspections to make sure everyone remains safe. But that doesn't mean it is a requirement. So let's break down what this waiver actually means. So once again, this is only relevant for conducting in-person initial inspections. So these inspections are waived if the grantee has notified HUD of their intent to use this waiver or any of the extensions in previous waivers per the directions in each memo. The grantee has approved their project sponsors the ability to use this waiver, and the initial inspections will be conducted using remote methods such as technology and video streaming. This was an early, there was a webinar on this topic about how to do virtual inspections, particularly using technology. We'll make sure to throw that webinar link into the chat. So if you do have any specific questions about how to do virtual inspections using technology, you can refer to that previous webinar. So some quick reminders when it comes to this property standards waiver. So this waiver is set to expire on March 31st, 2022. Once again, any initial re-inspections conducted remotely must be completed in person by 6/30/2022. So this only applies to those initial inspections. If you need to continue to do remote inspections for annuals or following whatever your previous policies and procedures were for annual inspections, you can continue to follow that. Project sponsors, if you have any questions, please make sure to reach out to your grantee so that you are all following the same policies and procedures. And if anyone needs any more additional information on this topic, this was also covered in a previous webinar that we'll share the hyperlink for so you can follow some of the directions there, particularly about how to wrap up this inspection. Many communities have already wrapped this waiver up, and maybe they just need to reapply it for a few more units, right? So just follow some of the previous guidance on how to wrap up this waiver if needed. Now, the only thing that I want to add before we move on is to make sure that you're documenting the use of this waiver in a file. So if you have any questions about how to document this, make sure to reach out to your grantee. At this point, you all probably have policies and procedures about how to document the use of this and all the other waivers, not just within your agency, but also within your client files. So for examples, the webinar yesterday covered some of these, but you can also do things like just writing it on the inspection form itself. All of this is just to make sure that if HUD comes in to monitor or when your grantee comes in to monitor, it's very clear what you've done and why you've done it, particularly that it ties to the waivers that you were approved to use. So let's give a quick update on the HOPWA waiver for the FMR rent standard. So this waiver that had previously expired on December 31st is now extended and expires March 31st, 2022. This waiver allows grantees and project sponsors the ability to approve gross rent for a unit that exceeds their rent standards, provided that the gross rent for the unit meets rent reasonableness. And once again, for those of you who are just joining our session, later on, we're going to go into some of the specifics of rent reasonableness, just to make sure as a confirmation that you've been doing rent reasonableness correctly, that you're documenting rent reasonableness correctly, so you can really prove that you've been following this waiver. So what does this waiver really mean? Right, so the FMR rent standard waiver means that the gross rent for the unit may exceed your current rent standard amount, which, as you are all aware, is currently set at the FMR, or the community-wide exception rent. So you can go above your rent standard, that FMR community-wide exception rent, as long as it meets rent reasonableness. So HOPWA regulations had previously stated that units had to meet your rent standard and rent reasonableness. So now, for those units for which you've applied this waiver, the unit only has to meet rent reasonableness. But keep in mind, from community to community, you may not need this waiver, or even unit to unit, you may not meet this waiver. So particularly if you can follow your current rent standard guidance for units, please continue to do so. Also remember, without applying this waiver, you have a choice as a community to apply the 10-20 rule, meaning you can go 10% above your rent standard for 20% of applicable units. All of that guidance is still in place, right? So if you are looking at units and how to make sure they're fitting in any current requirements, you might need this waiver, you might not. So where are we now then with this rent standards waiver? So a quick reminder yet again, we just want to make sure this is clear that this option to use this waiver expires March 31st, 2022. So therefore, as you're looking at those utilizing your HOPWA rental assistance, as you're looking at the affordability of some of those units, remember that you could use this waiver anytime until the end of March 31st, 2022. But please make sure, once again, that your grantee has notified HUD of their intent to use this waiver, and that you followed all of your policies and procedures and documentation requirements to make sure that you're following not just the waiver itself, but documentation requirements for future monitoring. And when it comes to documenting this, once again, it's community by community. Some communities are just using their current rent standard form and writing at the top of it that they've applied the rent standard waiver. Other communities have their own form that they're putting in there. But once again, that idea that you have some sort of documentation in the file to make sure that it's very clear that you've applied this FMR rent standard waiver to this particular unit for this particular household. So since this waiver does end March 31st, 2022, we do want you all to start thinking about some post-waiver considerations. So particularly, what do you do when the rent standard waiver expires at the end of March? So here you'll see a hyperlink for some of the previous HOPWA webinars that have gone over this topic. So this will go into some of the specifics and examples that you should start to think through. We're also aware that this particular waiver expiration brings up some questions about HOPWA rent standard. And so we won't go into any specifics about how to create a HOPWA rent standard today, but please know that we are planning a upcoming HOPWA office hours on post-rent standard waiver options, right? So we'll be able to go through some specifics about what do you do. But before we get to that, right, we just want to give you some big picture questions to think through about what your agency as a project sponsor, or what you as a grantee managing your HOPWA portfolio, what are some things that you should be considering as this waiver winds down? So these post-waiver considerations, we recommend to track and forecast your rental assistance expenditures to determine if increased spending due to this waiver is sustainable, right? So you all have your contracts from your grantees. Grantees, you all have your allocations from HUD. There's only so many HOPWA dollars that you can spend. And so while the CARES Act did give you all an infusion of funds to help with costs such as these, if that's how you chose to use them, those were non-renewable funds. So you're definitely going to make sure that if you have units that this waiver has been applied to figure out what's sustainable and what's not long-term. So that means you're going to need to determine the exact number of units affected by this waiver. You're going to need to determine how much the gross rent for a unit exceeds your post-waiver rent standard, whatever that might be, right? So you could do that by looking at what would be your current rent standard, right? How much is that gross rent over your rent standard now? And while you have time before you need to make any changes, we'll go over that in just a moment, it will start to give you an idea of what it might look like as you do need to change the rent standard for that unit. And we'll mention this again, right? But if you haven't already done so prior to using the waiver, determine if the 1020 option is available for those units, right? Because maybe it's a little over your current rent standard, but there's no reason to apply the waiver if it's not needed. However, if you do have a number of units that are going to be over your rent standard waiver, or in general, whenever it comes to HOPWA's 1020 rule, please make sure you have some policies and procedures and some options available on how you would apply this rule fairly and in a non-discriminatory manner. Finally, some last things to think about for some post-waiver considerations. So, remember that once this waiver expires, it does not mean you immediately need to change the gross rent for the unit or units covered under this waiver. Right, so the waiver ends March 31st. As of April 1st, you don't need to look at all of your units and immediately change it to current rent standard guidance. Right, if it can, that's up to you as an option, particularly as you're following your policies and procedures. But keep in mind, per HOPWA guidance, the earliest any changes would need to be effective in that unit would be at the first annual recertification. And depending on your policies and procedures, the latest you could go is up through the second annual recertification. So we'd like to remind people this is really no different in a way than how you would normally apply rent standard amounts that end up being lower than the previous years. So particularly for you out in the community who've been around for a number of years and have seen your rent standard go down because the FMR decreased or your community-wide exception rent decreased, you've had some policies and procedures on what to do in those situations. Those generally follow these rules outlined here, right? That you can go up until the second annual recertification before you need to apply that rent standard. So at this moment in time, you can think through and apply that same policies and procedures to these units, taking a little bit of that pressure off about what do you do come April 1st. So because gross rents amounts approved as part of this waiver are subject to future rent standards adjustments, my apologies, such as when HUD releases new FMRs, right? So what you're going to want to make sure is how you're operationalizing this in your community, particularly so households and your landlords are aware. So if they aren't aware yet, make sure that households assisted and landlords are aware of the higher gross rent and why it was approved. Make sure assisted households and landlords and owners are aware of how previously approved gross rent amounts might change and might affect their ability to remain in the current unit 1 year or 2 years out, right, when you get to that first or second annual recertification. You can also, as of today, make sure your HOPWA policies and procedures describe when the lower rent standards are applied. So particularly if you are a community that currently says these apply at the first annual and you'd like to switch it to the second annual, make sure that's updated in your policies and procedures. Project sponsors, and make sure to contact your grantee and they are aware to give you all some flexibility in this. But when it comes to this, just remember that if you're whatever your policy is, whether it's applied at the first or second annual, you don't want to surprise assisted households or your landlords with these changes, and particularly if someone either has to move out of the unit to keep their subsidy or give up their subsidy to remain in the unit. So make sure you're discussing this with households and landlords. You're communicating all this information to them as soon as possible, but definitely no later than that first annual. That way everyone has time to plan and figure out what might be coming down the road to make sure that you're securing their permanent housing. So those are our considerations when it comes to the waivers in the last memo. So because you still have until March 31st to apply, particularly this rent standard waiver, as promised, we want to go into some information on rent reasonableness to make sure you all are doing rent reasonableness correctly, documenting that in the file so that you are applying this waiver to its fullest ability in a way that will keep your agency protected at monitoring. And with that, I'm going to turn it over to Heather.
Hello, everybody. Welcome to today's session. So in section 3, we're going to be talking about rent reasonableness and doing a little refresher on some important information about rent reasonableness and how to do rent reasonableness. Next slide. So what do HOPWA regulations say about rent reasonableness? The rent charged for a unit must be reasonable in relation to rents currently charged for comparable units in the private unassisted market and must not be in excess of rents currently being charged by the owner or that landlord for comparable unassisted units. Under the HOPWA program specifically, for the gross rent of the unit, the client unit, or what we like to call the proposed unit, to be reasonable, the gross rent for the proposed unit must be at or below the average of the gross rent of the comparable units. We have had questions in the past. What if, for example, a landlord doesn't have any comparable unassisted units, right? What happens if the unit in the building that the client is renting from, all the units are assisted, for example? Then this part of the definition then wouldn't apply in that case, right? So what you would want to do is just make sure you document that. Next slide. So what is the purpose of rent reasonableness? Well, ultimately what it is, it's a function of just doing due diligence to make sure that the rent being charged, right, to the client and to the program is fair and reasonable for units participating in and being assisted with HOPWA funds. It also helps ensure reduction of waste of government funds. And it also helps to ensure that rental assistance programs do not unintentionally inflate rents in the community. And it aims to make sure that quality units are made available so that eligible applicants are not restricted in where they can live. Next slide. So what are some rent reasonableness considerations when you're developing a policy for rent reasonableness? It's important that you establish a methodology for researching and documenting comparable units, right? You want to figure out what kind of resources you're going to use and where you're going to find your units, in addition to how many comparables you're going to use. Some programs use 2 and some use 3. Standard practice is around 3, but we've also seen programs use 2 for comparable units. Staff assignments. This is just essentially referring to who is it that's going to be doing rent reasonableness and completing the paperwork and searching for comparable units. Generally, it's the same staff that are, say, for instance, working with TBRA. It would be the TBRA staff, the same staff that are doing rent calculations, determining eligibility for tenant-based rental assistance, and doing inspections. You're going to want to develop file checklists and forms. For example, how the checklist will determine and keep a record of the qualities or factors of the proposed unit and all the qualities and the factors associated with the comparable units, and provide a good level of documentation for when you have a HUD monitoring visit, because you have everything all in one place. You're going to need to determine when rent reasonableness will be conducted. Generally, this is going to be occurring before someone moves into a new unit, right? When a landlord submits a request for a rent increase, you're going to want to conduct rent reasonableness to make sure the new requested gross rent for the unit meets rent reasonableness. And you're also going to do it as part of your annual recertification process. Lastly, you're going to want to establish strategies for addressing special circumstances. These are things like it may be possible that there are units in the community that might need to have a higher rent amount. For example, first 4 units or units that are handicapped accessible or units in buildings that have an elevator, things like that. Next slide. So what is a comparable unit? Okay, a comparable unit are other units that have similar features or factors to the proposed unit. Only unassisted units in the private market can be used as comparables. For example, a unit assisted with HOPWA TBRA cannot be one of the comparable units. So you wouldn't go to your TBRA program participant files, right, and pull files from 3 clients and take information about those units and use those as comparables. They need to be unassisted unit. A few more examples of types of assisted units might include home assisted multifamily properties, units that have a Section 8 housing choice voucher, either tenant-based or project-based, or another local, state, or federally funded assistance program. This does not, and remember, when you're looking for comparable units, you may not always know if the units are assisted, right? But this is the fact that if you do know, then you can't use those units as comparables. Next slide. So what are the reasonableness factors? There's quite a list here, right? So we're looking at location, quality, size, unit type, age, amenities, housing services, maintenance, and utilities, whether those are supplied or not. And a few examples about each of these means location is related to where is the unit located. It's not necessarily simply the town or the city in which the unit is located. It's the specific part of the city or town, right? Because rent for a unit may be at a certain amount because of the very location of the unit itself. So that's important. Quality. Is a unit newly constructed, well-maintained? Is it adequate, excellent, good, poor? Items like that. Size refers to number of bedrooms, 1 bedroom, 2 bedroom, single room occupancy, 4 bedroom, etc. Unit type. This is, they say unit type, but to me, this seems more like a building type. This is units that are either like a high rise, a duplex, low rise, single family housing. Age just refers to the age of the building. If it was newly constructed, is it 5 years old, 10 years old, 30 years old, or even older, depending on what area you're working in. Amenities. Now, these are things that you might want to think about, something like a deck or dishwasher, a washer and dryer is supplied, washer dryer hookup, carpeting, central air, community pool, on-site security, playground, or community room. Just some examples of housing amenities. Housing services. These could be literally, maybe there are some kind of supportive services on site, or more than likely, this is like property management type services. And maintenance, is there on-site maintenance, or do they have to call out for maintenance? And the utility supplied is really self-explanatory. Does the landlord supply all the utilities to the unit or some of them? Who is responsible for which utilities? So those are factors that you would need to collect information about the proposed unit and then your comparable units. Remember, some of these factors may drive actual price or the amount of rent a landlord could get, but some of them might only affect desirability, meaning that it would rent faster. Generally, the more important of the reasonableness factors that affect price or location of the unit, right? Like where in the town is the unit located or where in the city, number of bedrooms, and the type of unit. So you're thinking location, where, size, 1, 2, 3, 4 bedroom, and type of unit, high rise, garden, duplex. Next slide. We get this a lot, right? And I'm sure this has come up. We especially, both Steve and myself, because we both live in Maine, and Maine covers a very rural area too. So what can you do if it's difficult to find comparable units in a certain area? If there are only a few units in a particular area, you may need to expand your search, like we call your search radius from the proposed unit. You could also expand other features. Some examples, some things you can kind of mix and match to find comparable units are you could use the same size and type, but expand your search. Go out 15 miles from the comparable. Go out 20 miles from the comparable. This can be especially helpful for rural communities. You can use the same size, same geographic area, but other types, right? So in relatively the same radius. Remember, same radius doesn't mean they're exactly on the same street, right? They're relatively close together. And same size, you could use you could do 2-bedroom units in the same area, but you could use a high rise and a duplex, that kind of example. You could also do same size, different type, and broader geographic area. If you expand these factors and you still can't find comparables and you've documented all your efforts, you've done your due diligence, right? You would be considering in this situation, the gross rent for the unit is reasonable, right? So document all your efforts. So if you absolutely say couldn't find 2 comparable units, but you could find 1, then document that and put that in the client file. If you couldn't find any, then write all those notes down and say which kind of mix and match search you tried to use. And then you should be all set. And you could determine what we like to say, kind of quote, the gross rent for the unit meets rent reasonableness. Anything to add to that, Steve? I know that we have had, I think, a couple of times in the past where that might have even happened to us. And we were really concerned about, we couldn't find any unit. We did all this expansive search. And so I thought that would be a good resource for folks.
No, nothing to add. I absolutely agree. I think particularly in a lot of areas, in rural areas, it's hard to find those comparables.
Yeah, it is. Absolutely.
Your due diligence and prove it that you followed the guidance.
Yeah. Okay, next slide. So how do you find comparable units? Next slide. Thanks. So you could use public sources, rental websites, web-based rent reasonableness resources, or rental database. So what are some examples of each of these? So for public sources, we're talking about, it may be possible that other organizations in the area in which your organization is located collect data on rental stock in the area that they serve. For example, a local, state, or public housing agency authority might have information on rental units for which you can use to do your rent reasonableness. Rental websites, this is referring to what we all know, like Zillow.com, rent.com, apartmentfinder.com, anything like that.com, right? That you could find information about comparable units that match your proposed unit. Web-based rent reasonableness resources. Now, these are the best in my view. So this includes something like socialserve.com or gosection8.com or other types of web-based resources where both Steve and I used in the past, we were both grantees, we use socialserve.com. I know not every state has this available to them, but we would do, it was a web-based resource. We would very quite literally go in, enter all the information about the proposed unit, pick a radius, and then it would load in how many comparables we want. It would load 3 comparables, we always use 3, right into this nice form that laid out all the characteristics and factors of the proposed unit, and then the 3 comparables. And then from that final, we could determine if the gross rent for the unit met rent reasonableness. It saved a lot of time. You could also create your own rental database. Just make sure if you're creating your own rental database, they're using a wide variety of units. You're not just only using units for which you think your clients would be approved to live in, right? That's not the purpose of rent reasonableness. Make sure you're using, if you have a client, if you want a range of like SROs, 1 bedrooms, 2 bedroom, 3 bedrooms, different rent ranges, different factors, and in different areas, different geographic areas where you provide assistance.
Heather, here's a quick question that we can address on this slide.
Sure.
So if you're using public sources, rental websites, right, all of these resources listed, would you know whether or not the unit's being subsidized and if you could use it as a comparable or not?
You might not. So that's sort of the short answer. In most cases, you probably won't know it's subsidized unless there is something on the web base that literally says the building is subsidized. Otherwise, you may not know that.
But if you're not sure, right, would it be a safe assumption that unless there's something telling you it is subsidized, that you could use it as a comparable?
Yes, absolutely. Yeah. Next slide. So how is rent reasonableness documented? Okay, programs must maintain documentation for the basis of the rent reasonableness decision in client files, right? This is all going to go together in your client file because it's unique to the size unit that client and their family was approved for, right? Along with the inspection form, the rent calculation, all of that information is going to go together. You're going to want to provide clear information about how the comparable units were identified and how rent reasonableness was determined. For example, you're going to want to record information about the unassisted comparable units, right? So if you're doing this kind of what I call longhand, right? You have a rent reasonableness comparison chart. I believe there is one on the HUD exchange. I think it's in the HOPWA administrators. I think there is one like a rent reasonableness form that you can use. You're going to want to show your methods, right, about in your calculations how you determine the gross rent was reasonable. Identify the person conducting rent reasonableness. That's easy. Just have program staff sign the form. Record the date of the determination. And written verification from property management company or owner attesting the rent charge is not more than the rent charge for unassisted units. Basically, and that's if it's applicable, right? If there are other units that are all like 4 bedrooms and your client's moving into a 1 bedroom, those won't necessarily be comparable. But if they're comparable and have similar factors, then you're going to want to get that information. And basically, this is just to make sure that a landlord or a property management company isn't charging a higher rent just because somebody has a subsidy or rental assistance. Oh, great. In the chat box, you'll just see, you'll notice the rent reasonableness checklist. And this is a great place and a great tool to record information about your proposed unit and then all the comparable information. Remember, if you're doing it longhand and if you're going to Zillow.com to find your comparable units, print something out of your comparable unit. Print the comparable unit number 1, 2, and 3, fill out your chart, staple it all together, and you've got something for the file. So next slide. So here is just a little example, a pretend example of a completed rent reasonableness chart or form. So here on the left-hand side, we have the factors or qualities. And notice they're not, I think they're every one of the ones I mentioned earlier. And then we have the proposed unit and 3 comparables. And see how they're similar. And you notice too, there's nothing here that says like radius, like you don't have to write in the proposed unit is located at 04101, right? And 04103 is 30 miles away, which it isn't because these are main zip codes. But just note, you don't have to write down the actual radius. This just gives you an idea of the items that you're going to be collecting. I circled utility allowance here because after you've collected all the information about your proposed unit and your comparables, you're going to need to figure out, are the utilities included or not included, right? And then you're going to need to find a way to account for that because you're going to want to know what the gross rent for the unit is. So you're going to want to have information about the proposed unit, right? What utilities are included, not just heat's not included, cooking's not included, but how is the unit heated? Is it oil? Is it gas, right? Is it electric? And then you would want to collect that information to the best that you can about the comparable units. In most cases these days, if you're going to using, like Zillow.com or Apartment Finder, it's going to list utilities that aren't included. And you'll be able to figure out like what type of source that is also. And then what you would do is you determine the gross rent for the unit. So let's take a look at, let's keep going and take a look at what you would do next as far as utility allowance. So if you have a unit in which utilities, some or all, not included in the contract rent, and here I apologize, this was a term we didn't use earlier, but we refer to contract rent. This is simply just the rent requested from the landlord, right? In the, the contract. So the lease with the landlord, between the landlord and the tenant, it's a contract. So it's the contract rent. So what you're going to want to do is to figure out a utility allowance amount to determine the gross rent. You're going to want to use a utility allowance schedule like you would anyway when you're calculating portions of rent, right? And so you're going to be getting that from the local public housing agency or authority in your area. And then you're going to examine the form and you're going to select the cost items that are applicable to the proposed unit and the comparable units. Let's look at the next slide. So here we have an example, okay, of a utility allowance schedule. I borrowed this, I can't remember from which area. It might have been Maine or another state. But here, what I did was, you'll see some information that is highlighted. So you have unit type, right? Remember we talked about the type of unit, low rise, walk up, road, garden, townhouse. Those are all relative, kind of the same. The date of the utility allowance schedule, so you know it's up to date. And then in this example, the proposed unit is a 2-bedroom unit. So I'm going to go through and I'm going to highlight every area. And I see here too, there's some numbers not showing up. So we'll make sure that's fixed before this is published. So I'm going to go through and highlight or circle all of the utilities that are applicable to the 2-bedroom unit. And I'm going to fill out the rest of my form and add it up. And down here, you'll see the very bottom, this tiny, tiny print, it says 264. You notice in this example, down below in the notes, I have comparable unit 1, 2, and 3. And I did the same thing. I just didn't do a new utility allowance form. I used the same form and I just put notes down here, figuring out what the utility allowance may be with the information I was able to gather about the comparable units. So that way I would know how to fill out the rest of my chart. A comment that we wanted to make here, you'll see this like nice little red circle. Reminder, the range, microwave, and refrigerator allowance only applies if the range and or refrigerator must be supplied by the tenant, meaning the landlord doesn't supply those appliances. Okay. If that's the case, if the tenant needs to supply, say, for instance, a range oven, they could supply themselves a microwave instead of a range or an oven. This is acceptable, and this would meet HOPWA habitability and housing quality standards, whatever inspection method you're using. A microwave allowance, though, is not provided simply because a tenant has a microwave. This means if the landlord does supply the refrigerator, all the appliances, and the tenant has a microwave, you don't give them a microwave range allowance. This is only when the tenant has to supply and chooses to supply a microwave in lieu of a range or an oven. So I just wanted to point that out. So you wouldn't be giving that allowance at all. Okay. Next slide. So let's continue. We're going to be completing this checklist from the previous two slides. So we know what our utility allowance is. So we're going to go through and complete the rent reasonableness form. We're going to plug in all the utility allowance amounts and get our gross rent for the unit. So your contract rent plus a utility allowance is going to equal your gross rent. We have all these amounts below. So see, the gross rent for the proposed unit is $949. Comp 1, $964, comp 2, $959, comp 3, $1974. $1959, sorry, I think I said $959. Next slide. And then what I'm going to do here is you're going to add them all up and get an average, and the average gross rent of the comparable units is $965. The gross rent for the proposed unit is $945 compared to $965. So in this example, we laid out how does this apply to the waiver, okay? Let's say your rent standard normally for a 2-bedroom unit is $1,800, and and somebody finds a unit. And it's, see, $949 is over $1,800. So you want to be able to use the waiver. You could use the waiver in this situation. Why? Because the gross rent for the unit meets rent reasonableness. The gross rent for the proposed unit does not exceed the average of the gross rent of the 3 comparable units. The gross rent for the proposed unit meets rent reasonableness. So you could approve the gross rent for this unit. You could also, as Steve mentioned earlier, maybe given your rent standard is $1,800. I don't know, Steve, you want to do the math really quick? Say your rent standard is $1,800. He's laughing, but I'm totally serious. So your rent standard is $1,800. Why not first check to see if this could fit? Say you haven't used the 10/20 rule yet, right? So, or say you've used it for only a few units. You could check to see if this gross rent could be applied to the 10/20 rule. So if you could go up to 10% for add an additional 10% for up to 20% of your units. So then in the situation, you may not even need to use the waiver, right? But say if you are using the waiver and you've maxed your 10/20 rule, then you could still approve this because it meets rent reasonableness.
And I think Heather really helped summarize that well, although I was a little having some flashbacks to middle and high school math of being called out to answer a question.
but called out to do percentages.
But Heather's right. If your rent standard currently is $1,800, up to 110% of that is $1,980, meaning you could apply the rent standard waiver, or if you don't want to worry about how to wind that down, you could use the 10/20 rule as an option. So this is once again some of that implementing and how do you operationalize this? So, right, you don't have to put all of these units against the waiver and have to worry about what to do with them later. So particularly if your program has the budget to take on the additional costs, if you haven't used all of your 10/20 options, you could definitely just apply the 10/20 rule as you would for
Yeah.
any other unit.
Yeah. And why not check that first? You're in there doing the math anyway. Why not just check that first? So we can go to the next slide. And questions.
We have a few questions. And our friends from OHH, if you're still on, I think I'll throw the first two over to you. So OHH, is the self-certification of zero income still allowable? I'm assuming in conjunction with the idea that the self-certification waiver has ended.
Right. So self-certification of zero income has always been allowable under HOPWA. And actually in that same HOPWA program administration toolkit that we have on the HUD Exchange, there is a HOPWA zero income affidavit that grantees and project sponsors can use as documentation when a household has no income. So I will actually put a link to that in the chat box as well.
And then Amy, while you're still off mute, the next question's for you.
Sure.
Can a lease be more than a 1-year term?
Yes. So without knowing the full context about why that question's being asked, I will answer it. And then if we didn't get it exactly right, you can either follow up here on the webinar or submit an AAQ. But as a general rule, the lease between the tenant and the landlord must not be for less than 1 year, but it can be more than 1 year and should allow for renewal after that period. But grantees and project sponsors can approve a shorter initial lease if the shorter term would improve the housing opportunities for the tenant, and that's really the prevailing local market practice. I mean, generally the lease lengths will be what the local requirements are and what the general prevailing practices are. But just as a general rule, the guidance that we have put out is that they should be at least a year.
Absolutely. And so particularly if there's additional follow-up questions or specifics for that, let us know. Definitely also see what is applicable for your state law, right? Because we can give HOPWA guidance today, but we definitely can't go into the laws for all 50 states and applicable territories, because while we could say Amy's answer was spot on, if your local state says a lease can't be longer than a year, then that local law would trump HOPWA regulations. So there,
go ahead.
Oh, sorry, I was just going to answer a question about if using the rent standard waiver, how does this affect the consumer when your HOPWA funds or HOPWA CFE funds are no longer available? So first, just to keep in mind, the waivers are applicable to all of your HOPWA allocations so far, right? So if you're a formula grantee, previous allocations, if you're a competitive grantee, those awards and your CARES Act funds, right? So you have the CARES Act funds as an option to help cover some of those. So keep in mind, right, you should have had in a program design where I'm sure you're tracking your budget before you're issuing vouchers, before you're approving rent increases, before you're approving units that go above your current guidance. So assuming you've done all that, once the rent standard waiver ends, there's nothing that you need to do at that moment in time. However, if budgets are starting to get tight, look at your current policies and procedures about what to do. How do you apply an updated rent standard to a unit? Is it the first annual or it's the second annual? And I think similar to the previous question, if there are some specifics here that are going to be applicable for follow-up, let us know. We can reach out, submit a HOPWA AAQ, and we can work through specific issues or details that your particular program might be having.
There was one question too about how much distance is appropriate for rent reasonableness assessment in rural areas. There's no stated rule or regulation about distance in miles. I would say that, you know, your people are the expert about their own area and where they live and where units can be found. I would just, document all your efforts. And, the further you have to go out, if you have to go further and further, just document why you needed to do that. If anybody else has anything to add. I know if we were doing it in Maine, way up north, we would have to go far, far, far. And we know that because we live here, right? And so we're the expert on that area. So I would rely on my knowledge of Maine and then document that information in the client file to support, my due diligence efforts to make sure that the gross rent for that unit was reasonable.
No, and Heather, do you want to take the next question as well? There's one additional about.
What is an appropriate radius? I think that depends on the area and, where you're searching and the unit type and the factors related to that unit. You could start out, if you're in a, like a smaller city, where there, there are generally a lot of rental units and you have a rough idea that there are a lot of 2-bedroom or a lot of 1-bedroom. You could start, with like 5 miles, 10 miles, start smaller. And then if you're having trouble finding comparables, then you could, move out your radius.
What about if someone can't find the age of a building when doing rent reasonableness?
If you're looking and you can't find, on the real estate resources, and if you can't, do a quick search, like some towns have information, in the city on the age of the building. If you can't find that information, then I would document your effort saying that you tried this resource and include that information in the file, and then complete the rest of your rent reasonableness. Not being able to find the age of the building to me wouldn't make or break your you doing due diligence to make sure the gross rent for the unit meets rent reasonableness. Just document all your efforts. Usually you can find that. Sometimes you need to search, like, for example, we would search like the city real estate record. Sometimes you can see that information. Some of that is public knowledge, and you could, log in and just check the address of the building. Or if you have a rough idea, include, a rough idea. I know in Maine, some of the buildings are like really old. So we'd have to write the age of the building, like 1901. You might not even know, right? The records may not even be completely accurate because the original building might have been in 1901, but part of it was rebuilt in 1980, right? So I would just do your best to try to find that information. If anybody has anything to add, or please.
No, I was just thinking, particularly when I was doing this, that it's really just doing your due diligence. So if you can't find it, you can check a few resources, right? But the age of the building wouldn't necessarily be something that would exclude your ability to use it for rent reasonableness, particularly because that might be difficult. There are some other things that you should obviously know, like utilities included or not included, that you wouldn't want to skip those specifics, but just be reasonable when it comes to doing this and document what you did and why that number is not there. I do want to encourage people people are throwing some things into the chat box about how they're finding information on units when they need it. So that can definitely be useful for some of these questions, such as using other websites like Zillow, contacting a clerk, particularly if you have that relationship. Right. Absolutely. Right. It's never a bad idea to have a city clerk as a friend. That can help in many things, particularly in rent reasonableness. Right. So, right. So that's definitely good. Yeah. There is a comment in the chat that I did want to address. It looks like it's too long for the question, but it's about implementing the 10-20 rule. Right. And so is there a required way that a program would implement the 10-20 rule? So for example, do grantees have to split up a certain number per project sponsor, right? Is there any current guidance or regulations about how a grantee would implement the 10-20 rule?
That sounds like an Amy question.
It does. I would also say submit into the, but what I'll just say off the top of my head is my understanding is that the regulations or maybe it might not even be our regulations. Our guidance has said that there needs to be an equitable manner that that this is determined. So, I mean, policies and procedures really need to be developed about how you would implement that and implement that in an equitable manner, so that you know, it doesn't disproportionately impact certain folks in certain areas, or
Absolutely.
yeah.
So particularly, right, you wouldn't want to automatically exclude certain areas and say, right, you can only use this in urban areas, rural areas you cannot.
Right.
But also when it comes to implementing, as Amy was sort of saying, it's all about your policies and procedures. So we've seen grantees that ask all of their project sponsors submit to them before they implement it at all. Some equally distribute it to project sponsors. Some do it on a case by case, because there are some project sponsors that might never need it in their particular part of particularly a state, right? They'll never need it, and then other jurisdictions will. But in that still, right, is still making sure you're not doing anything that inadvertently violates any HUD regulations like fair housing or disproportionately affecting communities. So definitely agree for that. If there's any specifics you'd like to think through, submit an AAQ, right? So we could dig into the specifics of that.
Also too, when you are doing it, just to add, ultimately it is the grantee's responsibility to track how many units, right? Even if the choice was to divvy it up, the grantee still needs to track, you know, if 20% have been are over 10%. So just keep that in mind.
So there are some additional questions that have come through. So do agencies have to fill out a completed rent reasonableness form for each client that is receiving rental assistance?
Well, however you document your rent reasonableness is related to your policies, but you do need to do rent reasonableness, say for instance, for, you know, if you're doing TBRA or facility-based housing, master leasing. So yes, you need to do rent reasonableness for everybody, regardless of COVID. That's just a HOPWA regulatory requirement. It's a good idea to have a rent reasonableness form and checklist, because that way your information is very organized and it's very clear, you know, that you did it. And it's definitely a treat when you are, you know, have a on-site visitor or remote visit from your field office, when they open up a file and they can see that rent reasonableness is done, everything's documented on the form, and then you have your comparables accompanying that form. So however you choose to do it, just make it sure it's organized and it's very clear. There's another question too, are difficult to house due to background, criminal record, landlords are only doing month to month. Would this be okay with the program?
I mean, generally our guidance says, has said that a shorter lease is allowable if that expands, you know, improves housing opportunities for tenants. I would say though that if this is an issue that you are facing a lot in your program, maybe something like master leasing might be a better idea as far as activities to fund, where the project sponsor organization or the grantee actually holds the lease and then subleases to clients. And that model is particularly beneficial for folks that have backgrounds that can keep them from getting into housing or securing a lease.
Yeah.
So yeah, I don't know if Heather or Steve or Rita, you have any.
Yeah, I think that's a great idea, and that would be especially helpful because in that situation too, it gives those clients and tenants a chance to have a lease, right? So to be in a lease period, they could have a lease for a year. And then later, if they wanted to, like, you know, move on into a non-master leasing program, they have that sort of tenancy reference of being able to maintain a lease for a year. So it gives them that good, a chance to build that good tenant history.
Heather, I was just going to say the same thing, and we also where some grantees are able to do that while keeping that household in the same unit.
Right.
So it adds to their stability while also building that,
right
for them.
Yeah. And then sometimes too, the landlord, it may be possible too, if say a project sponsor or grantee is leasing, it's scattered site, or they're leasing a bunch of units in a big complex in different apartments. After a period of time, maybe the grantee or the project sponsor wouldn't have to master lease that particular unit anymore. And then the lease could just revert back to the actual owner, landlord, and that tenant. And so they wouldn't even have to move if they didn't want to. I mean, sure, they could, move to a new unit too, but they could, just release up in place with the actual landlord. So remember, rent reasonableness is really about doing your due diligence, right? Just making sure that the gross rent for the unit, for the proposed unit that the client's going to be living in, meets rent reasonableness. So we just wanted to give you a refresher and a background about the waiver itself and what it means and how you apply doing rent reasonableness to this waiver. I don't see any more questions.
All right, with that, just a reminder to stay tuned as we went over some of the materials when it comes to winding down the HOPWA rent standard waiver, particularly some questions to think through. We'll have office hours in the future about some more specifics on this, particularly how to operationalize any changes to your rent standards. We always like to remind people, not just through links in the chat box, but all of the great resources at the HUD Exchange. So this is that reminder: previous webinar resources and guidance, COVID resources for other programs are all there. Particularly, there's a bunch of the things that we cited today were things that existed well before COVID-19 and are just as applicable. So please make sure to look through the HUD Exchange for some of those resources. So you're all aware the property standards waivers office hours from December is posted there. So if you have any questions about property standards, please make sure to review that slide deck and recording. And we'll end with, if you have any other questions, right here's our contact information. Grantees, if you need more, particularly on some of the topics today or some of the issues brought up, reach out for technical assistance. And also for anyone listening, if you have any questions, please submit a HOPWA AAQ. That's definitely a place we can get to some more specifics and follow up to try to answer the questions as well as we can with the information presented. With that, that is our presentation today, everyone. We thank you all for your time today. We thank you all for your hard work, particularly in the middle of winter and some of the COVID outbreaks. So thank you for that work and for spending some time with us today. We really do appreciate it. We hope you're all safe and be well, everyone. Take care.
Thank you very much. Have a great afternoon.
Well,
Thanks, everyone.